Madam Devi, the State Authority has approved the alienation of this land to you as compensation for the acquisition of part of your land.
I understand. What is required from me?
This is Form A.
This scene marks the beginning of the dispute in Teh B and K. Marutamutu. Teh B was granted a piece of state land as compensation after part of her original land was acquired by the government. To formalize the alienation, the State Authority issued Form 5A to Teh B. Form 5A is a statutory notice under the National Land Code which set out the premium, fees and conditions that must be complied with before ownership can be complete.
It states the amount of the premium and other payments that you are required to pay.
Okay, but how long do I have to make the payment for?
You are required to pay the premium within 3 months from the date stated in Form 5A.
But what is the date stated in the form?
The date stated in Form 5A is 16 November 1966. Therefore, the payment must be made within 3 months from this date.
One of the most important conditions stated in Form 5A is the time limit for payment. Under the applicable land rule in Negeri Sembilan, the premium must be paid within 3 months from the date stated in the form. Failure to comply within this period may cause the approval of the alienation to lapse. In this case, the date stated in Form 5A was 16 November 1966. Accordingly, Teh B was required to make payment within 3 months from that date. However, although the approval was given, the payment was not made within the prescribed time.
Please take note that failure to pay within the specified period may cause the approval of alienation to lapse.
Okay, I understand. Thank you very much.
The premium was eventually paid on 12 October 1967, which was approximately 8 months after the expiry of the 3-month period stated in the Form 5A. This delay later became a central issue in this case, raising questions as to whether the state authority still had the legal power to alienate the land and whether any defect in the approval process could affect Teh B's registered title.
I'm so excited to look at my land. What is this?
Oh!
Who are you?
Hey, this is my land. You have no right to be here.
Look at this land. I've been living here for a very long time. This is my piece. I'm here to apply a TOL, temporary occupational license.
In 1952, Marutamutu first occupied the land. At that time, he occupied the land under a temporary occupation license, commonly known as a TOL. A TOL allows a person to temporarily occupy state land, but it does not confer ownership. It is granted for a limited period, subject to renewal, and may be terminated by the state authority. Despite its temporary nature, Marutamutu remained on the land for many years, from 1952 until the end of 1967. He lived and worked on the land, gradually improving the structure at his own expense.
Okay, wait. Oh, there's a TOL for this land.
Okay, I take this one.
Okay, sign here.
Makin lama ke kalau koma. Kumakin ni.
This is my shop house.
During this period, Marutamutu paid license fees and assessment rates, and no action was taken to remove him from the land. In addition to residing there, he operated a small provision shop, which is kedai runcit, consisting of wooden plank walls and a zinc roof. Later obtained water and electricity supply and cemented the floor, gradually improving the structure. Over the years, he depended on the business for his income and continued to invest time, effort and money into maintaining and improving the building. As time passed, Marutamutu came to believe that his long occupation and continuous use of the land for business purpose and improvement made at his own expense gave him a legitimate claim to remain on the land. This prolonged occupation and commercial use later formed the basis of his defense, as he argued that his prior occupation and investment should prevail over Teh B's registered title.
That does not matter. This land is registered under my name. You must leave immediately.
I cannot live just like that. I bought this place with my own money.
Look at this. I have my Form 5A. This land has been alienated to me.
I also have the license, the temporary occupational license. I've been occupying this land since 1952, and I will be planning to renew this license this year.
This is my land. You go.
No, I've been occupying this land 20 years. What's wrong with you?
I am evicting you now.
No, let's settle this out.
Mr. Marutamoto, how can I help you?
Hi, I want to renew my TOL for 1968.
I'm sorry, Mr. Marutamoto. It looks like the land has been alienated to Miss Debbie.
Huh? How can? I've been occupied this land for 20 years.
In 1968, when Marutamoto attempted to renew his temporary occupation license (TOL), he was informed for the first time that the land he had been occupying had already been alienated to another person. This came as a shock to Marutamoto. In fact, as early in 1965, he had been applied for alienation of the land in his own name and was informed by the authorities that his application was still under consideration. Believing that his application was pending and relying on his long occupation, Marutamoto continued to remain on the land. He was unaware that the state authority had in the meantime approved the alienation of the land to Tehbi. This discovery later formed a key part of Marutamoto's defense, as he claimed that the alienation was carried out without his knowledge despite his prior occupation and pending application. The magistrate court ruled in favor of Tehbi. The court accepted her claim that Marutamoto's continued occupation of the land amounted to trespass and held that his temporary occupation license did not give him ownership or proprietary rights. The court rejected Marutamoto's argument that he was entitled to compensation for improvement and that the notice to vacate was unlawful. As a result, Marutamoto was ordered to vacate the land within 3 months. No damage were awarded and each party was ordered to bear their own costs. The High Court overturned the magistrate decision. The court held that Tehbi had obtained her title unlawfully, as the State Authority Act contrary to Section 81 and 180 of the National Land Code 1965, due to her failure to make payment within the time specified in Form 5A. Although the State Authority has the power to alienate the state land under Section 41 and 42 of the National Land Code, the High Court emphasized that such power must be exercised strictly in accordance with the law. Where the state authority acts beyond its statutory power or illegally, the alienation is a nullity, and any title based on it is invalid. As a result, the High Court ruled against Tehbi, prompting her to appeal to the Federal Court.
The court notes the following points regarding the appellant. First, the fact that she was registered as proprietress raises the inference that the state authority, upon payment of the premium, had given fresh approval for the alienation of the land to her. Second, the fact that the registered document of title is in her name is conclusive evidence that the title to the land is vested in her. Third, under the torrent system, the register is everything. It would be wrong to allow an investigation into the right of a person to appear on the register when they hold the certificate of title. Lastly, the court further notes that there is no evidence that the state authority intended to give the land to anyone else. It will be seen that the act of registration itself is paramount. Once the title is registered, it becomes indivisible and remains so unless and until it is declared otherwise by the court. Such a declaration can only occur if the title is successfully challenged within the limited scope of the exception stated in Section 340 of the National Land Code. Therefore, the respondent must vacate the land in 1 month and pay the cost of the appeal in High Court and this court.
And so, the Federal Court's decision confirms the principle of indivisibility of title. Under the torrent system, once land is properly registered, the title is protected by law. The court's ruling ensured that Tehbi's ownership is secure, and any challenge outside the strict legal exception cannot succeed. Justice is served and clarity is brought to land ownership under the law.
Yay!